Among many courses that is offered by students who aims to become tomorrow lawyer, contract law is one of the bases of such courses. And contract law is a very fascinating aspect of law in the sense that it is the core principles of civil matters. Everything that is not criminal always tends towards contract law. That's why in this video, I'm going to take my time to explain to you every single thing you are going to expect in law of contract as far as first semester is concerned, because I strongly believe that you clicking this video shows that you are ready to face contract law and face it and excel in that course. If this is the first time you are coming across this channel, my name is Kingsley. I'm currently a 400 level law student, and what I do on this channel is to make helpful videos that will help students, especially law students, to pass through the challenges of becoming tomorrow lawyers. If what we do here resonates with your ambitions, you can consider subscribing and turn the notification so that every Saturday and Wednesday you'll be able to receive a video. Having said that, let's begin. To make the entire practical guide of this video easy for you, I have decided to group this video into 5 critical stages. So at the last end, which is the 5th stage, I'm going to recommend some certain textbooks for you, which you are going to use in order to be able to pass this through course. Now, let us get to the first requirement. As a person who has passed through his year 1, you are now about to face contract law. Be that as it may, contract law seems to be the only law course that has no universal application when it has to do with offering the courses. Many schools offer their own in year 1, some offer their own in year 2. I've even seen some schools that offer it in year 3. So I would like to know the particular university you are watching from, and possibly tell me whether your own school offer it in first year or second year. This will go a long way to help me identify with you and make a post that will be tailored to your own university. Now, the first stage of things you are going to anticipate or work on as a person who is preparing ahead in law of contract is nature of contracts. So under this first stage, you'll be introduced to the workings of law of contracts. You are going to understand the definition of contract, and believe me, take it from me, contract law is the only law course that requires your definitions. Like, it is the only law course that the overall definitions is needed. So you are going to know the definition of contract. In fact, it forms one of the bases of where you will be tested for some lecturers. For this case, you are not just approaching it with the definition of contract from your elementary, secondary school knowledge. According to my understanding, contract can be defined as this. No, you are going to have defined it in line with judicial or erudite authorities which has made a pronouncement on law of contracts. Somebody like Professor Itesege is an erudite authority who has defined contracts. We also have the case of Oriental Bank International and Bilante, which also gives in Nigeria ingredients or jurisprudential definitions as per contract law. We also have a lot of definitions of contract law. Many cases, many authorities have defined contract. So you are going to know it. I have made a video specifically in this channel that addresses every single work on contract law in first semester. So when I'm done with this video, I'm going to link the playlist in this video so that you'll be able to watch it at the end of this video. So under this first stage, you are meant to know everything about the nature of contract. Here on the first stage, when you are done with the definition, another thing to consider is the sources of contract law. You know, like we all have seen it in legal method, we have sources of law, right? Primary and secondary sources. Also in contract law, there are sources of contract law. You are going to know how contract law originated from. What are the things that enforces contract law? Where does contract law has its precedent from? From there, you are going to see the common law sources of contract law. You're also going to see the customary sources of contract law. How our foundation, how the customs of our people have over the years shaped the contract law. How the common law has over the years dominated the contract law. How the statute to some extent have also come to define contract law. There are so many states that have their contract law that governs it. Sales of goods is one of the, a statutory backing to contract law. Hire Purchase Act, these are the main sources of contract law that has in many ways shapes the application of contract law. So under this nature, you are going to know all these things. And this channel, I've covered most of these things. Once I'm done, I will link you up to videos that addresses this. Still on the nature of contract law, you are going to know what is known as consent of bargain. Contract law basically has to do with promises. Keeping promises and making promises. I'll promise you that I'll buy a car for you if you do this, if you do that. You are accepted. So it is all about bargaining. Contract law has its roots in concept of bargaining. So you are going to be introduced to distinguish actually what makes a contract binding, because not all contracts are binding. We're going to underscore the points and the relationship between the contract law and concept of bargain, how promises exchange, and to what extent does a promise you make to your neighbor becomes a binding on you. So these are the things we are going to know under this nature. Then still on this nature again, you come to see something that is very unique. That is forms of contract, or what may be regarded as classifications of contracts. In this case, you are going to know the difference between formal contracts and informal contracts, express or implied contracts, or executed or executory contract, or unilateral or bilateral contracts. Are you getting my point? So under this stage, you are going to know everything that has to do with formal contract, informal contract, express contract, implied contract, executed contract, executory contract, unilateral contract, bilateral contract. These things are opposite. They are antithetical to each other. Informal contract is opposite of formal contract. That's why I outlined this using that disjunctive conjunction. So I believe you are flowing and you are getting the point. The essence of this video is to actually help you so that you don't wait on your lecturer. If you are a person who has finished his 100 level, or your school do offer contract in your 100 level, this is the best time to begin, because contract law is unique, it's fascinating, and it can be quite challenging because of the cases and the voluminous nature of contracts. The topic may appear simple, but when it gets to it, a single line in contract law always has a case in it. A single pronouncement or topic will always have thousands of cases that expatiate that. Contract law has nothing to do with statutory law. It is basically more of cases. So that's why you have to start early. Then we move to the second stage on our video. Under this second stage you are seeing on the screen is where it actually gets more tricky and where it actually gets more serious. This is actually what makes or breaks any contract law student. Under this second stage, you are going to have what we know as formations of contracts. In this stage, it is believed or presumed that you have understand the contract law, the definitions, the nature, sources, and here you are meant to then know how contract is formed, the formation of contracts. Here you are going to know the elements of contracts. We have something that is known as offer, we have acceptance, we have considerations, we have intention to enter into a legal obligations, we have the capacity to contract. In fact, at this stage, we are going to examine everything that makes the contract a valid one under the law. That's why I told you ab initio when I was dealing with play bargain, that play bargain simply has to do with exchange of promises. To what extent does it, do you bargain and make promises and exchange promises? But then formation of contract has to take it further to tell you that it is not actually all promises that are binding. Offer must be unequivocal. Acceptance must be wholeheartedly. Consideration need not to be adequate. And so many more. There must be what we know as intention to enter into a contract. Consensus agidem is what we call it in Latin. Meaning that each party must be aware that they are entering into a contract. Now, there must also be a capacity to contract. You cannot contract with a baby to marry her. You cannot contract with a child to take his father's land. That child or that baby must be of equal age. What is the valid age under the law of contract? 21 years, not 18 years. Labinger and Abegg has that. So that is what you are meant to understand under this formation of contract. And I have made a lot of videos that dwelt on it. So we proceed to the third stage. What I plan to do now is to help you extraordinarily, so that if you are reading this, possibly if you are someone that is studying this, anticipating your academic comeback for the semester, it is important to take note of this case. Number one is case of Kalili and Carbolic smoke ball. It is the locus classicus case. Like, it is the chief authority when it has to do with element of contract as far as offer and unilateral types of contract is concerned. So when you talk about offer as an element, Kalili is there. You talk about unilateral contract, Kalili sit there and mount like a full general. Then when you talk about consideration, we have the case of Musa and Kuri. Still on offer and acceptance, we have the case of Pharmaceutical Society of Great Britain against Boots Cash Chemists Limited. That is a very locus classicus case that differentiates, what offer means and invitation of treat means. You are going to see it as you progress. You're also going to talk about the case of Thomas and Thomas. That case is very interesting. It is a case that, tells you everything you need to know about consideration. Consideration doesn't mean please consider me. Consideration when it has to do with law simply means what you have to give in order to, to make a contract binding. Is the gum, is the super glue that gums a contract. Without it, it's just as good as placing your hand like this to move. But if there is super glue here and you place it within short of period of time, it will gum, right? That is what consideration is all about. Gumming the contract to make it a valid one. It's a very, very vital element when it has to do with element of offer. So these are the things we are going to do at this stage. We basically come to the third stage. When you are talking about third stage, pay attention here. Third stage has to do with terms and representations. This third stage will introduce you to understand how contract works. It's not everything that is enforceable under the law of contracts. So this place will introduce you to the terms of contracts. So after this stage of your academic career as a law of contracts student, you'll be able to distinguish between what is binding contract and what is a mere presentation that doesn't form a part of the contract. A breach of terms of contracts could lead to termination of a contract. But then a breach of non-fundamental terms will not lead to the breach, to the total collapse of that contract. So what this place as a beginner, and this is not the video to teach you that, but as a beginner, what you should expect while reading this thing is that this is a contract. Is there anything that will make it not to be binding? Is there anything that will tantamount to having the contract, not contract, but merely persuasive talk, but merely a puff? You are going to see certain terms. You are going to see fundamental terms. You are going to see a lot of terms and clauses that could limit a contract applications. Still under this subheading, which has to do with terms and representation, you're also going to see something that has to do with excluding and limiting clauses. For instance, I believe we all used to see a scenario, or if you go to a park, they will say at owner's risk. Parking here is at owner's risk. This thing means that, yeah, you are coming to my shop, you are coming to ShopRite to purchase. We owe you a duty of care, both on the point of law of thought, to ensure that your vehicle is safe. Both on the point of contract you are forming with us impliedly here by stepping your foot into ShopRite. Yes, it is a contract between us that you came to buy you and came to entertain and secure everything you are going to do as far as transaction is concerned here legally. But then we notify you that parking your car here is at your risk. This thing now, if the matter goes to, if anything happens to your car and there is a notice here that says that parking car here is at owner's risk, that ShopRite or that park will not be held liable because they have used what we call in law as excluding or limiting clauses to their liability. So if you go to court will be like, well, there is a notice here that it is at owner's risk. So why are you disturbing us? They are not liable. Whether you take notice of that or you didn't notice that, it is immaterial. Because under the evidence law or under equity, you're also going to see something that has to do with actual notice and constructive notice. I don't want to bother you, my dear. Just take it from me. Let's continue. We shall get to that when we reach that level. We'll pass it normally. Then move to the first stage. Under the first stage, like you can see, we are going to see something very unique and different. Here you are going to see capacity in its full fledged as a topic. Remember we dealt with capacity, I think in the second stage when it has to do with formation of contracts. Capacity as one of the elements of a valid contract. Here you are going to treat capacity in its own corporate capacity. So what you are going to treat here is capacity of a minor to enter into a contract. When we talk about minor, we talk about children. Whether a contract that is entered between a child is a valid one. We have Labinjo and Dabek. We may consider reading that case. It's a very locus classicus in the whole African jurisprudence. We're going to know whether a capacity, a mental person or an insane person, a mentally incapacitated person, whether the contract entered with him is a binding. You are going to know what they call lucid interval of a madman. A madman may not be held liable at all times for his contract, but when he's in lucid interval, there are series of madness. In fact, there are some certain of your classmates that are mad, but their madness will only come bit by bit. One day they are okay. After reading contract law, they are mad again. So you will be able to intervene the chain of their madness to examine when they will be held liable. Whether their madness is at a 0 peak or at 100 peak will determine to what extent they will be held liable for the contract they had with you. Here also, you're going to check the drunken person, the married woman, and all those things and all those things. This topic, this one I mentioned is the sweetest. It was where I cashed out in my year 2. The first book I'm recommending to you, I'm recommending or making this recommendation based on how helpful the textbook was to me. So it depends on you too and your own ability to understand. But I seriously and strongly believe that whatever works well for me surely will work well for any person that is watching this video. Because I found this course difficult, and I will have no doubt as whether you find it difficult. Because contract is actually a difficult course. I'm offering you to have this textbook, MC Okane, Commercial Law in Nigeria. It is true that this textbook has something like commercial law in Nigeria, but it has element of what? It started with contract and then progressed to commercial law in Nigeria. You understand? So it covers everything. And the beautiful thing is that you are going to use it in your law of contract and also use it in what? In your third year, depending on the school you are watching from, on commercial law. Then the most popular noted one I'm also recommending is the one written by Professor Itesegi, Law of Contract. It's actually popular. Yes, it's cut across almost in Africa. But the problem I have with the textbook is that it was very bit technical. It was written with, that English mentality, because the author is actually, should I say, he grew up in the English war in England. So he wrote it with that level of Odogu in him. So the textbook, it was not relatable to me in particular. I don't know for you, but it's the most popular one. You may easily see it in the market. In fact, lecturers use it. But recommending it for me, no. I prefer MC Okane, Contract Law, or any other textbook that is not this Professor Segi. Because if your lecturer uses it is expected you must use it as well. But then have a backup plan. Then if you are from any countries within the common law in Africa, or even India, because I know that most of Indians also watch my video. So if you are in any of this country, or in fact in the whole world that is applying common law as a rule, there is one textbook that is very popular, Answering on Law of Contract. It is where both MC Okani, Professor Ite Sege, it is where they all borrow their ideas from. Answering on Law of Contract is the chief textbook that dwelt and dealt with contract. We also have Chiti on contract and so many more. So these are the major ones I'm highly recommending for you, and I believe it's going to help you. Based on the video I talked about, if you click the playlist above, this video has everything you ought to know. The video above me now, it has every single thing you ought to know about law of contract as far as first semester is concerned. When you go there, check the video and you are going to see how all of them helps you.